In a nutshell, like how would you describe what the process looks like so people have an idea of what to expect?
Well, we definitely do all we can to keep the process streamlined and as simple as possible for clients. Basically, we first have a free consultation, typically 20, 30 minutes, phone call. It can either be with one party and then the other party separately, or a conference call with everybody on there. And then the clients decide whether they want to get started or not. If they get back to us and say, yes, let's start things, Janessa sends out an email that has the first invoice, because we break it up into payments, the fee agreement, which is pretty straightforward, no legalese in there. It's a very short fee agreement, and the first questionnaire. So once we're hired, the clients provide us with that completed questionnaire. The first one's pretty basic, just like contact information.
Yeah, basic information to fill out the initial pleadings, which are the basic forms to open a case with the court. And then from there, I send out some follow-up questionnaires to gather information about assets and debts, and also income and expenses of both parties.
So once we get the completed financial questionnaires back, that's generally when we'll schedule the mediation session. And that can be within a week or whatever, depending on everybody's schedule. It can happen pretty quickly. Those financial questionnaires are very helpful for me to be prepared, so I know what we're going to cover when we sit down to talk about everything. I have the information to run support calculations, start to think about some potential solutions for, property issues that are involved.
And then I also will use those questionnaires to fill out your financial disclosures, which the court requires parties to exchange between the two of you. The nice thing about working through agreement and out of court is that those financial disclosures are only exchanged between the two of you. They're not filed with the court. So that makes sure that your financial information remains confidential.
At the mediation session, we just cover issue by issue. Generally, if there's minor children, we start talking about custody. We cover legal custody, how that works, physical custody, how that works, go over the different options, come up with at least a tentative idea of what each party wants, hopefully an agreement that works for both of them. And then we start discussing the finances, generally like for short-term or monthly finance issues having to do with support primarily. Child support, I run support calculations, explain how that all works, go over the different options. We also go over spousal support, how that works, comparing the different types. There's temporary, there's long-term. There's a formula for temporary, but there isn't for long-term. So I explain, and give some guidance on what a court would likely do, or what attorneys often do in settlement to come up with what the reasonable amount of spousal support is. And then we move next into discussing property and debt, whether there's houses involved, retirement involved, savings, investment accounts, whatever, personal businesses, probably some of the more complex issues involved when someone operates their own business. But however complex it is, we go through step by step. Sometimes we need to take baby steps to make sure everybody's on board and understands everything, but we cover all of that until we have at least some sort of tentative understanding or conceptual agreement, or at least narrow down some options. And then after that first mediation session, that's when I prepare a rough draft, or sometimes a little bit less rough and more complete, depending on how far we've gotten through everything. Circulate that to the parties, and then we use that as a working document to continue discussions. So we can refer to that, highlight in there, any information that I might need, or issues that still need to be resolved, and some different options that we discussed during the session of ways to resolve that. And then we schedule follow-up sessions if needed, or work through everything through phone call and email, just kind of depending on how complex or how much more time is needed to get through everything else. Once we have a finalized version of that, I prepare that, we send it out with requests for signatures on everything and full instructions on what we need to get back. Most of all of it is electronic signatures. The court accepts those on everything except one of the signatures. Whoever the respondent is, their signature on the settlement agreement needs to be an original signature, and it needs to be notarized. We do it that way to save the $435 of the filing fee for the response. Once we get all of that stuff back, we submit the judgment paperwork to the court, and we're done. Then it's just a matter of waiting for the court to process everything, which can take anywhere from 1 to 3 months, I would say, on average.
Great. Well, I'm Janessa. This is Michael. We're Conscious Divorce. You can reach us at consciousdivorce.com. Give us a call at 619-800-1801. You can send us a message on our website, or you can send us an email at info@consciousdivorce.com.